it pushed together in 17 different colors. And my eyes are good for this much. So whenever you're ready, President Sloan.
Okay, let's go. Are we live?
We are. Go ahead, please.
All right. Good afternoon, everyone. I would like to call this meeting to order, the NIAA Special Board of Control meeting. So at this time, if you would please stand for the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America
and
to the republic for which it stands,
one nation, under God, indivisible,
with liberty
and
justice for all.
Thank you. All right, we're going to go to item number 3 on page number 3, roll call. Tia, I'm going to turn it over to you.
Pamela Sloan.
Here.
Rollin Stallworth.
He is here. He is here. He can't hear yet.
Linda Cavazos.
Here.
Greg Malkovich.
Here.
Jay Kenny. Colin McNaught.
Present.
Christina Brockett.
Here.
Wade Poulsen. Brian Freeman. Rayanne Sorensen.
Present.
Alex Woodley. Keith Whipperman.
Present.
Dennis Holmes.
Here.
Miles Baldwin.
Here.
Ken Parker.
Here.
Austin Mao.
Here.
Tammy Habig.
Here.
Teresa Burrows. Domingo Rivera. Dave Henneman.
Here.
I hear it now.
Ellen Townsend.
Here.
Xavier Anthiam.
Here.
Trey Lundeen. Emerson Wendell. Elsie Moore. Timothy Jackson.
Here.
Paul Anderson.
Here.
Bart Davis.
Here. And for the record, Mr. Woodley has joined us.
Thank you. Sean Fitzsimons.
Here.
Kate Segroy.
Here.
And myself, Tia Wonder.
Thank you. I'm going to turn this over for announcements. Mr. Jackson.
No, I have no announcements right now.
Thank you. We'll go to item number 5, public comment. This time provides an opportunity for citizens to address the board about any matter or not on the agenda. Items raised during this portion of the agenda cannot be deliberated or acted upon until notice procedures of the open meeting law has been complied with. Should a member of the public wish to speak on a matter not listed on the agenda, it is asked that said person please complete a yellow public comment card and submit it to the president before the opening of the item. A limit of 3 minutes per person and/or 5 minutes for the spokesperson of a particular group may be imposed. It is requested that comments be directed to the board as a whole. Comments that are determined to be irrelevant, repetitious, offensive, inflammatory, willfully disruptive, or deemed to be personal attacks will not be permitted. I do not have anyone or know of anyone here. Tia,
do.
Tim?
There's no one in person, but we do on Zoom.
Okay.
Yeah, we do have somebody on Zoom. Taylor Tonages from Faith Lutheran, I believe, is here with us.
Yes. Am I good to begin?
You may begin, Taylor.
Okay. Good afternoon. Thank you for the opportunity to speak. My name is Taylor Tonagis, and I'm the head cheer coach at Faith Lutheran High School. First, I want to say how much we appreciate the decision to sanction cheer in Nevada. This is a major step forward for our athletes and our programs. My concern today is specifically about the proposed requirement that tryouts be held in November in order for cheer to be classified as a winter sport. That is at its core a safety issue. Competitive cheer is a highly technical sport that includes advanced tumbling, stunts, pyramids, and basket tosses. These skills require months of progression training, conditioning, and repetition to be performed safely. Under the proposed timeline, teams would hold tryouts in November and then be expected to compete less than a month later. That is simply not enough time to safely build a routine at the level required for competition. In past seasons, we've received choreography in early August and did not perform our first full out at practice until mid to late October. And at that point, it's not ready to compete. We don't do that until mid-November. With that timeline, we carefully layer skills and prioritize progression to reduce injury risk. Compressing that preparation into just a few weeks will significantly increase the likelihood of injuries. Sanctioning should improve safety standards, not unintentionally create new safety concerns. So I would respectfully ask, is it truly required that tryouts be in November to classify cheer as a winter sport, or is it a matter of bylaws that have not yet been adjusted to reflect the unique structure of cheer? Other states have found solutions. For example, states such as Pennsylvania, Arizona, Texas, Florida, Connecticut, Maine, and Colorado sanction cheer as a winter sport, but allow spring tryouts. Another approach is seen through California. They sanction cheer without confining it to a strict seasonal model, allowing teams to compete throughout the school year. If Nevada is willing to allow teams to compete at nationals outside the winter season, then perhaps we can consider a structure that better fits the year-round nature of cheer and do something similar to California. We all want the same thing, growth for the sport and protection of our student athletes. I respectfully urge you to reconsider the November tryout requirement and prioritize a model that keeps athletes safe. Thank you for your time.
Thank you so much. Is there anyone else? Tia, you have any written comments or anything, Mr. Jackson? I do not.
I do not.
Okay. All right, thank you. We'll go to item number 6, approval of the agenda for February 23rd, 2023. I would ask that the motion also state that's flexible.
Rayanne Sorensen, I motion for a flexible agenda.
Thank you, Rayanne. We have a first.
I'll second.
Thank you, Rollins. We have a first, we have a second. Any questions, comments? All in favor, say aye.
Aye.
Any opposed? The ayes have it. Thank you. Now, if you would please go to page number 10. These are, I need approval of the minutes for the January 27th, 28th, 2026 NIAA Winter Board of Control meeting. I'm looking for a motion.
I'll motion to approve those minutes for those dates listed.
Thank you. We got a first, looking for a second.
Second, Alex Woodley.
Thank you, Alex. We have a first, we have a second. Any questions, comments? Hearing none, all in favor say aye.
Aye.
Any opposed? Thank you. The ayes have it. We will now go to item number 8, closed session. Closed session pursuant NRS 241.015 to receive information from legal counsel regarding potential and or existing litigation involved matters over which the NIAA has supervision, control, jurisdiction, and advisory power, and to possibly deliberate towards a decision on the matter. At this time, we need to go to close. I need a motion to go into close.
No.
No.
Pam,
No
Pam,
motion.
this is Paul Anderson, legal counsel.
Okay.
I don't believe we need a closed session. We had a pending legal matter, but it's since been resolved, and I think, I believe Mr. Jackson reported to the board on that last week.
Yep.
So no need for a closed session.
No need. Thank you, Paul.
You're welcome.
Okay, now let's progress. Let's go to page number 9, workshop public hearing to solicit comments on proposed regulations returned from the LCB. Kate, I'm going to turn it over to you.
Thank you. So I just want to bring your attention to page 28, which is up. Those 5 asterisk regulations are the only brand new ones as part of this file. So this entire file is a combination of a couple older files that were related to changes we were making to our transfer regulations that have been worked on for several years. The additional new 5 are the reason this had to go back to a full workshop, because they are all included now in one file number with 5 brand new regulations that we've never talked about. Those regulations, as you'll see when we go through them, are related to changes made through AB 184, Assembly Bill 184, and are required by law for us to change. And so that's why we're here as a workshop versus just, reviewing our regulations that we had already approved and sent to the LCB and for their writing. What you'll see as I go through these is the majority of those regulations are good to go, those ones from the past, and the 5 that are brand new are referencing Assembly Bill 184. So we have to approve or deny this as one big file versus individual regulations. So it is quite a bit, but please feel free to stop me, raise a hand or something to indicate that you need to stop me at any point. I'll try to pause between each of them since there are a lot of regulations here. So before we get started, does anybody have any questions before I get into just reviewing these regulations? Okay. So go ahead and move down to page 31, the bottom of 31. The very first section of this file is in regards to our one-time transfer rule, essentially. So the language in blue is all exactly what has already been previously approved for the one-time transfer that was submitted to the LCB. What you'll see is an addition that I've added in green that was not included that has reference to Assembly Bill 184. My concern with this not being a part of the regulation is that it may appear that a student could get a one-time transfer through our regulations and a one-time transfer through Assembly Bill 184 in a different year. And so I wanted to be sure that we included something that basically says a student can use their one-time transfer, can get full eligibility through a transfer if they have not already used this waiver, this one-time transfer through our regulations, and also has not used their ability for immediate eligibility through Section 7. And that is the section in AB 184 that specifies that you can transfer prior to 10th grade or you can transfer to a school with a lottery with full eligibility. So that is the only real change here. First, what we had originally written for this regulation. And then as you can see in subsection 5, just to remind everybody, if they have used this, any subsequent transfer would fall within our transfer regulation, which is NEC 385B 716. So that regulation is a part of this, so we'll review that as well. Questions on our one-time transfer?
Hey,
Mhm.
just really quick, if approved today, is there one more pass back here, or is this now the rule?
So the problem with it is we are amending a piece, that green part. So it does have to go back to the LCB, and they'll have to review to be sure that that language is okay and fits and follows, all law, and it does need to be sent back. So we would likely have to do one more approval from the board before it goes to a hearing.
Okay, copy.
Good
Thank you.
question.
Because we
Yep.
are kind of doing this like month to month thing right now, right? That's at least our plan. This is going to be somewhat quicker than normal, it seems, right? Because it will probably be in effect for next school year. Is that like the general plan?
That's the hope. And the thing with this is we already really have a lot of the mechanisms for a one-time transfer in place since AB 184. So there's not going to be any changes that really need to happen and activate. It'll just be based on our approvals. So whenever this gets approved, whether it be in June, July, August, September, even into the school year, it will be law when it gets approved. So those transfers, that were affected that would now have eligibility, we would just make a second determination for those transfers, similar to what we did with AB 184 when we implemented in August.
Sorry,
Hey,
final point of clarif. Oh, sorry, Mr. Anderson, go ahead.
Oh, sorry, I didn't mean to interrupt, but we do have to have the regs approved and in place according to AB 184 by July 1st, though, correct?
Yes, so anything that is referencing AB 184 does need to be in place by July 1. So I would hope that they would help us with that quick turnaround.
Yeah, I
Okay,
think they will. Yeah.
So just the clarification, the final one I was going to check is that if this comes back to us and it's in blue again and it's good to go, when we like, at what point does it become law? Is the question I'm asking. Like after the LCB
Once
gives it to us, and then
No,
Yeah.
no.
So after we approve it, after our board approves and we send it back to them, we have to wait until they have a legislative hearing for the regulation. And that group does the final approving, and then they send it forth to the Secretary of State for signature. So whenever that next meeting would be after we approve it finally. Tammy? Sorry.
Just, yeah, no,
Pam,
you're fine. Just so I want to make sure I heard correctly. That part that you added in green says
Mhm.
that they cannot use the one-time transfer and AB 184. It's one or the other.
Yeah, that was my purpose in putting that language in there so that they couldn't say, okay, well, I used AB 184 last year to go to a charter school, and now this year I want to go back to my zone school, so I'm going to use this transfer regulation here so they can't use two, essentially.
No, that's perfect. I wanted to make sure that I understood that correctly. Thank you.
Yep.
And Kate,
Anything else on this? Yep.
Kate, this is Paul again. Just to be clear, on AB 184 allows the one-time transfer in certain situations, and it outlines what those are. And the purpose of our regulations is to comply basically with AB 184. That's why you're putting the language in, right? Here.
No, I put the language in here so that our regulation can't be used as a secondary one-time transfer.
Right. So it's so that we're complying with 184, and we're just basically saying under 184 there's one-time transfer and that's it. You don't get two shots.
Yeah.
Right?
Yep. It's both. Yeah.
Okay. All right.
Now, I would like to add, can you hear me?
Yep. You're good.
Okay. I was under the impression that this new one would provide a junior from transferring as well. Is that not part of
Correct.
this conversation as well? And when we say a
This one-time
junior,
transfer. Yeah, this is for everybody, any grade, any school type, one time. So a junior, a senior, doesn't have to be a lottery, can transfer. And that's the reference here to AB 184 is to say, you still get a transfer there, but if you've already gotten your immediate eligibility under that, you can't also use this.
okay. Does this get rid of 184 after the first year if this is passed?
No, AB 184 is law. It's a bill. We don't have any control over any changes to that bill. This is to go along with it to create more equity.
Okay, so basically kids will have the legislative 184 bill and possibly the NIAA bill to transfer one time.
Right. And essentially with us creating this, it basically is that they don't need to use AB 184 because we already will have a regulation that allows a one-time transfer under any circumstance. So they don't really even need to use AB 184, but I felt it was necessary to put this language in here so that they don't look and say, oh, I have two one-time transfers to use.
And Kate, this is Paul and Rollins. That's kind of what I was trying to clear up with my last question. AB 184 amends and adds to the statutory scheme that the statutes that address the NIAAs. That's an NRS 385B. Okay. And part of it requires us to put in implementing regulations, which is what we've done here. And that's the idea, Kate, right? Is the amendments that we're making to our regulations are in essence to be complying with AB 184 and allowing a one-time transfer under those circumstances, correct?
And to go above and beyond that. Yeah. And to go, our reg is above and beyond what AB 184 allows.
Right.
So that everybody gets one.
But you can't say I'm using the statute and now I'm using the regs. You only get it one time.
Yep.
And the major difference in our county would be that a kid could use AB 184 to go a school choice, but another student who didn't get selected in that school could use this bill or this regulation.
Enrolled. Yep. If your school allows them to be enrolled in another way, then yes, they could use this bill.
Okay. That's the difference. Okay.
Or use this regulation. Yep. Anything else on that? I know that's kind of the biggest one that we'll review. So I want to make sure everybody's got their questions out on that. Okay. All right. Section 3. This is a regulation that was a part of our transfer regulation, our original transfer regulation that we have 716. We've pulled that to be a separate regulation to be housed alongside our recruiting regulation since it's more relative to those and relevant to those. And so the green that you'll see are the only changes we've made since we originally drafted and approved this. The board approved all the blue language previously. I added the green because in rereading this as we were going through all these regulations together, I realized that it made it sound as if a student that's enrolling at a school for the first time in 9th grade would automatically be ineligible if they played in their feeder program middle school that they've been zoned for their whole life and they're going to their zone high school. And we didn't want to penalize those students who are staying within their school. And that could be a charter or private school as well if they are a K-12 or a 6 through 12 school and they've been at that middle school participating with that school's programs in middle school. We don't want to penalize those students. So the green language is the only new language. Everything in blue is actually existing language from prior. But before anything that we've drafted, this language, was just pulled from 716. 2, as you see, just says the ineligibility that's set forth in subsection 1 does not apply to a student who's enrolling for the first time. So not a transfer student. You're enrolling in 9th grade for the first time after attending the middle or junior high program within the same school or zone public school in that assigned feeder alignment. So we don't want those students to be penalized, if that makes sense. Any questions on that one? This is essentially our Oregon rule. Again, it's been around for a long time here. So, okay. Moving on to section 4. This section goes over, this is a brand new section. This is related to Assembly Bill 184. This is regarding the level 3 appeals that are dictated by Assembly Bill 184. As you'll see in the bill, there's not a lot of specific language as to what the level 3 needs to look like. So this was drafted by the LCB. We did not draft this. They actually drafted this language. So I personally don't think there's any need to touch any of it because they feel as if this captures exactly what it needs to say based on complying with AB 184. So this is just one of those ones where we had to create something to just be in compliance with the bill. You'll see some of the very similar language that we have in our level 2 regulation 910. They just kind of pulled a lot of that language so that it matches. But it doesn't give a lot of very specifics on how that runs. It just kind of goes over the timeline essentially for that process. So any questions on that one? Okay. Section 5, again, this is a brand new section that we've never reviewed before. Compliance piece with AB 184. Section 7 is the transfer, the one-time transfer aspect, where if you are military prior to 10th grade transferring or going to a lottery system, you can apply for full eligibility. We talked with the LCB and felt it was important that we still had a regulation that doesn't necessarily go over the details of that section, but it does say that you have to notify us and use our process to be approved. So it's not just automatic where you're at the school, you don't have to do anything. You still have to go through Activate. You still have to go through the transfer system and be approved using the stipulations under Assembly Bill 184. So very simply just saying you got to use our process and then you will get approved through our systems. Questions on that one? Okay, moving on to 6. 342 is our recruiting regulation. This one is really just identifying the sections in Assembly Bill 184 that are also kind of paralleled to our regulations regarding recruiting. So it's just referencing that you may not, attempt to recruit or accrue, and it has to be in accordance with the language that's also in AB 184. A lot of similar language there. I think our regulation actually goes into a little bit more detail of some different, ways that we view recruiting, but that being said, here you'll just see in each of the subsections where they just reference that section 3 of the bill. And if you go down to 3A, talks about the penalties. There are penalties within the bill. And then we also just wanted to include 960. So you could also be subject to our penalties, which are fines and sanctions in that type of situation. 960 is basically our penalty regulation. So we're just kind of referencing both. There's penalties in AB 184, as well as you could be fined, for instance, which is not addressed in AB 184. So we wanted to add that in there just to be sure that we could still use our current processes as well as AB 184 as far as the penalties. And so the same thing is kind of listed for 4. 3 is about the school, and then 4 is the coach. So a little bit of repetition there as far as just referencing the bill. Any questions on section 6? And again, that is one of our new ones. We did not previously talk about this because we obviously didn't have Assembly Bill 184 when we were drafting our original transfer regulations. So that's a brand new one in there. Good. Okay, section 7, and for pretty much the majority of the next few are going to be regulations that were previously reviewed, approved by the board, passed. You will not see any green change to language, but I will still just go through and review them in case anything's changed and anybody wants to discuss them any further than we did the first time that we went through these. 704 is just removing language regarding schools and their ability to go beyond and be above and beyond our regulations. There was language in here about having to bring any of those stricter requirements to the Board of Control. We felt that hasn't really been a practice for a very long time, and that schools have that right and they can do that, and that's their school and school district choice. And so we don't feel it's necessary to bring every tiny thing like we're going to grade check every week instead of every 3 weeks or something like that to the board. They just can do that essentially. Any questions on 7? Okay, section 8. This is our residency and general regulation regarding where you are able to get initial eligibility. There is reference here that was added by because of Assembly Bill 184 that basically says, referencing section 7 and section 4 is the hardship section of Assembly Bill 184 that stipulates all the different types of hardships that you can use for eligibility. So this was something that the LCB felt needed to be added here, and that's what you'll see in most of these regulations. They went through all of our regs and said these are the areas where we need to reference the bill. So it was added to this regulation. The other difference, or there's no other difference here outside of just the things that we had previously approved. So the residential affidavit, we just changed the way that that's written, and there's a definition under subsection 8 that was previously approved. And then we also indicated in subsection 5, because we removed some other regulations, that a student enrolling in 9th grade is not using any form of a transfer to enroll initially at a private charter, magnet, vocational, or tech school, or obviously their zone school. So you basically get your first entry into the school of your choice as long as it is a private charter, magnet, or your zone school. Otherwise, you do need to use a transfer if you're going out of zone. And that just gives you your full initial eligibility at that school. And those are the only changes to our general enrollment reg. Questions? Okay, section 9, small changes here. This is our regulation regarding proving your residency, establishing your residency in the zone of attendance. The main changes we had here were just more clarifying what we actually accept. Since this is a question we get a lot from parents, they go on and they see outdated things like a telephone bill. There's not many people that still have a landline, so we just removed that. There was no gas or water bill listed, so we added that. Just kind of organized this section a little bit better. Took out some things like we don't take voter registration because that's a part of your license, so that's already an accepted part under D. Clarified some language in 4F that just says we may also ask for additional documentation as requested by the school district or executive director in certain situations where we might not have what we really need in what they've provided. And the last thing under 5 was just we changed it to any sanctioned sport. This is just kind of the subsection that talks about reestablishing a former residence. We had a level 2 where a parent felt the language was unclear in the section, so we cleaned that up a little bit to make sure that it was very clear what we were referencing here, that any sport that you play or want to play, you would be ineligible in 180 school days. Any questions on section 9?
Hey, Kate, real quick.
Yes.
4A says the sale of the former residence. We no longer need documentation of the sale of the former residence. We just need issuance of a new deed. Is that correct?
So this section, this particular subsection is in regards to your proof of current address.
Got it.
So,
Understood.
yeah,
Okay.
so it didn't make sense because we don't want to accept that as a proof of current. That's more of a document of abandonment, which is referenced in section subsection 3.
Understood.
Already.
Understood.
So
I thought we were taking it
just
completely out. Thank you.
no, it's still there. It's just unclear So we wanted to make sure that that wasn't put under where all the proof of address was. Okay, section 10. Section 10 is our transfer reg. This is our general transfer regulation. And of course, we now have a one-time transfer that you will get to use and not, not have the penalty of 716 as well as AB 184. But any subsequent transfers after that still have to have a transfer rule. So this still exists. This language is, again, there's no changes here outside of the reference to Assembly Bill 184. Everything else is as we had originally approved here, but essentially this change to our current transfer rule would mean that if you transfer to a school for the first time or transfer from another high school, that they will only be ineligible in any sport that they rostered in for the association during the previous 180 school days at their current school. So this is actually a big change. And again, this was already previously approved, but I just want to kind of revisit it to make sure everybody understands that not only do you get a one-time transfer, you also then, if you transfer again, are only going to be ineligible in any sport you rostered in the past year. A lot of times we have these hardships where a student sat out a year for whatever reason. It could have been an injury, it could have been something else. So they hadn't played the sport since their freshman year and they're transferring as a junior. And families felt it really wasn't fair that their student had to sit out again, even though they already sat out, voluntarily or whatever the reason was. And so we felt it was important to really just look at the last year, because that's what we're worried about here. If you've already sat out for some reason, that's fine. You've sat a whole year. So that change was made there. The next section. So here are ways to basically, here are your exceptions to that rule. So any general transfer rule, you're ineligible in anything you rostered in the past 180 school days. You can get a waiver, one, by going through section 2 of this regulation, which is the one-time transfer. So you can use your one-time transfer if you have not already used it. 2, which is B, is using the provisions of section 4 of Assembly Bill 184, which is the hardship section. So you can apply for one of those hardships essentially in that bill. And then C, you can rebut that based on our hardship regulations, which are parallel in a lot of ways, and go through the appeal process. So if you do get denied, you can go through the appeal process, hardships, any other appeal, or a level 2 hearing to rebut your ineligibility. So those are kind of your options there. Section 7, just in case you're wondering why it's not referenced here, is because you don't actually have to apply for a waiver. The language in Assembly Bill 184 says you have automatic eligibility. So it's not a waiver, whereas a hardship is a waiver, our one-time transfer is a waiver. So that's the reason it's not listed here, just in case anyone has a question on that. But obviously Assembly Bill 184, Section 7, the charter or COSA or lottery system and transferring before 10th grade is also an option, but that also falls within our one-time transfer since it's one of those types of transfers. Any questions? Okay, and then the language you see at the end, that's all in red, was that language we pulled into our separate Oregon rule regulation, but it is not gone, it's just in that regulation now. All right, section 11. This is our reestablishment of eligibility after a transfer with changes in guardianship. Again, just a reference there on the first subsection to AB 184, section 7 or section 4, I'm sorry. So that is just, again, required by the LCB to have that language in here, since if you have a hardship, it could supersede our regulation here. The only change we made here previously approved was legal to physical. I don't know why legal was in there. We always are concerned with physical custody of the student, not legal. So we updated that. And there was some language at the very end that was removed. A lot of this was repetitive language that we didn't need in this regulation, again, previously approved already. So there really is no other change to this outside of just referencing Assembly Bill 184. Questions on that one? All right, section 12. This is our magnet school regulation. We had originally stricken the entire thing. And then when we talked to the LCB, they did feel that it was necessary to keep some aspect of this regulations still. And we talked through that, and at the end, it did kind of make sense to keep this. We've just gotten rid of some of the requirements as far as complying with different stipulations of a magnet program. And this was more for equity reasons. We want to keep the transfer side of things very equitable. So you're not going to be penalized in a different way leaving a magnet program than you would any other program with this change. And so the other change we have here is just basically stating that once a pupil, if you've already enrolled in ninth grade somewhere else, and after enrolling in ninth grade and getting your initial eligibility, you then transfer to a magnet program, you can apply for a waiver of the requirements of residency. That's 7 and 12, the residency regulations, because most students are attending these magnets outside of their zone of attendance. And then if you scroll down to the blue on 43, you have to apply through our process, same thing going through Activate. And you can either get this eligibility through the provisions of Section 4, so a hardship, or you can apply, if you scroll a little further, you can apply using the one-time transfer if you have not already been granted a waiver. So it's just kind of going through, like, if you're going to go into a magnet program after enrolling in the ninth grade, you have to use some form of a waiver or one-time transfer to get your full eligibility. Otherwise, you're going to be subject to the transfer rule. So that's all that really says. So again, this was previously completely removed, but the LCB felt it was important to still have some aspect of this magnet regulation in there. And so we kept it with the stipulations you see there, basically just reiterating they have to use a form of a transfer or a hardship to get your eligibility. Questions on the magnet rule? Okay, 13, 734 is homeschool. This was all previously approved. We just removed some language about students remaining eligible. They have to now basically use some form of a transfer or waiver. This is just, again, an equity piece. That's why that was removed originally. The only new thing is under subsection 4. Again, the LCB felt it was important to add that a homeschool student that participates in their sanctioned sport is subject to not only all of our transfer regulations, but also AB 184. So they just referenced that there twice, section 7 and 4. Questions on that? Okay, section 14, 736 is our regulation regarding rezoning. So if a school, we're talking public high schools, rezone, just your generally zoned public high schools. If they rezone, this language has been in place for a long time. So that's all the same up to from 1 to 4. And we just added the word public to make it very clear that this is about public schools. And then 5 and 6 is actually language that we pulled from another regulation that we have gotten rid of. Again, that there's no change here. This is already previously approved. The language came back exactly as we had pulled it. It's not new language. It's just language that was moved from a previous regulation trying to consolidate. Because it's all, these two regulations were both talking about rezoning, we felt it just made more sense to put them together as one. So nothing new there, no new language. Any questions on that? Okay, section 15, 740. This is a brand new regulation that we had not talked about prior. Only reason it's come up is because it needs to reference Assembly Bill 184. So the LCB gave us this regulation and said, hey, we gotta plug this in here. This is basically the regulation that says that you cannot practice or participate in a sport for more than one school during a season. It's referencing the hardship section of AB 184, so that if a student does fall within a hardship, they would be able to play that sport in 2 different seasons. It's not referencing section 7, but that also is the case in section 7. So that means a student that uses their one-time transfer in the middle of a season through AB 184, going to a lottery, transferring before 10th grade, they do that in the middle of a season, they actually are allowed via that, that bill to play for 2 different schools in the same sport. And we actually have seen it happen this year. So just as a heads up on that one, we don't have a lot of leeway on that. That's required just by the bill. Questions on that one? 16, 742. Again, this was a regulation we did not previously talk about, but just has a reference there to AB 184. Again, the hardship part of AB 184. This basically says that when you're ineligible, you have to complete 180 school days if you are deemed ineligible prior to getting your eligibility back, which is kind of our general rule of ineligibility, except if you qualify for a waiver for hardship under AB 184 or under section now 3 is our hardship regulation, or if you go to a level 2 appeal and get it approved. So those are ways for you to get around your ineligibility. Questions? Section 17, 744, this is our out of zone waiver. So trying to think if there's anything new. I think the only thing that's new on this one is section 5. Everything else was how we had rewritten it. We did rewrite this regulation quite a bit, but essentially if you're not zoned for your school and you are going to go to a school that's out of your zone, you can get a waiver, and that waiver is going to allow you sub-varsity eligibility. That is, if you have not already used your one-time transfer under either AB 184 or our regulations. So you can get full eligibility going to a COSA, going to a school of choice, going to a zone variance if it's prior to 10th grade, or once this is approved at any grade. But if you are then going to a school out of your zone at a later time after using a one-time transfer, we still needed this regulation to be in place to let those students know you're only going to get sub-varsity if you have not already, or if you have already used your one-time transfer. So section 5 here is that new section, just basically says that the association, we will approve an application for any level if the student is granted the waiver based on section 4 or section 7. Again, they don't reference it because it's automatic. You don't need a waiver. So 4 is just a waiver if you have a hardship. 6 is our language we've always had for our own hardship regulation, or if they, go to a level 2 appeal, they can get full eligibility, and then they can always do it under section 7. Any questions on that one? Okay, section 18, 910, this is our level 2 regulation. This was one that was in a separate file from all of our transfer regulations, but they just combined them all. The language that you see referenced, basically it is things that we approved prior, where the school district can't act as counsel for a pupil. And then there's one section 10, that references Assembly Bill 184, because prior to that it said you can't appeal a level 2 decision, but now because of AB 184 you can, in section 6, do a level 3 appeal. So we just had to change that language where you can no longer appeal it, that you do have an opportunity to go to a 3rd level of appeal. So that language is the only new piece of this that we had not previously had in there when it was approved. Any questions on the level 2 reg? Okay, and then just to scroll, that's it for new language. If you go, these are the repealed sections, meaning we completely have stricken all this language. So 720 was our same attendance zone regulation. We basically created that as our transfer reg for every type of transfer. So there was no need to separate different types of transfers within zones and not within zones. So this was just completely removed. So every transfer is now treated exactly the same. 728 is option zone schools. We haven't had option zone schools in a while, so this was outdated language that we removed. And that is it. Questions on anything?
Good job, Kate. That was a lot.
Yeah.
All right, so we are looking to lump all of these into one motion. Is that correct, Paul? Kate?
Yeah, it's one
I think
file
that's
number.
the best way to do it, yeah. And
Okay.
the understanding, as we talked about earlier, would be that this is going to have to go back once again to the LCB for final look and approval and any revisions they want to make, and then return to the board again. So it's not the last time you'll see it before it would ultimately go to the Legislative Commission for final approval.
Okay, thank you. So I'm looking for a motion to approve the language on pages 29 to 55, if anybody.
Keith Whitman, I make a motion to approve the language and the changes, pages 29 to 55 for the LCB.
I have a first.
Second, Alex
Christina
Woodley,
Brackett,
Madam
second.
Chair.
Thank you. We have a first, we have a second. Any additional questions, comments? Hearing none, all in favor say aye.
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 Any opposed? The ayes have it. Thank you very much. All right, we will now go to item number 10, NAC 385B.106, non-voting member Board of Control for possible action. Kate, you're back up again.
Hey, it's me again. Okay, this will be quicker. So this we talked about in the September board meeting, and it was recommended that we first reach out to them to see if they'd even be interested, which we did. Tim reached out to Ms. Taylor and Ms. Torres Fawcett. Ms. Torres Fawcett did get back to us, said she'd be interested. And so we feel it's in our best interest to move forward with this, adding an additional liaison to our board for just more open communication lines between the legislators and us. And so this language you've seen before in that September meeting, we did not make any changes to that. And we would just be moving forward with an approval if it happens here, sending that to the LCB for their review for the first time. They haven't seen it yet.
Thank you. Looking for a motion.
Keith Whitman, for the record, I make a motion to approve NAC 385B.106.
Thank you. I have a first.
Second, Madam Chair, Alex
Thank
Woodley.
you. Thank you, thank you. I have a first, we have a second. Any questions, comments? Hearing none, all in favor say aye.
Aye.
Any opposed? The ayes have it. Thank you very much. All right,
Thanks, we'll get that moved on.
let's go to page 58. This is approval of regulation return from the LCB for possible action. Again, Kate, you're up again.
So this one was approved by the board, sent to the LCB. They've sent it back for us for final review to be sure everything looks as we would like. I do not believe there has been any changes. I reviewed these with what we sent them, and they, minus some small word changes here and there. The intent and everything we put in there is as we had sent it to them. Just as a heads up as we go into this, I won't go too far. There's only one small change we had to make, and you'll see that there on page 60. They had referenced the 24-25 NFHS handbook here, and I changed that link to just go to their publications page because the handbook changes every year. If you click on that link, it goes nowhere because we're on the 25-26 handbook. So that'll be the only change you see here. Everything else was pretty good. So essentially just to go through each of these regulations, this first one is regarding sanctioning of tournaments in events that need to go through the NFHS. And again, it's just referencing their handbook there, which I changed the link to. So that's the only change there. A school that participates in the sanctioned sport cannot go to an event, a tournament that is not sponsored by either us, the NFHS, or the state that they are going to. We've also included in here that the school has to submit to us the format of the tournament. These are things that we are practice, but we put them in regulation now to be more consistent, to kind of have some teeth behind it, to make sure this is being done properly. Again, this language had already been reviewed before and sent forth, so the only change was just that link there, but that's what that reg was. Section 4 talks about the actual application process for the sanctioning of the tournament, goes over our process, what we ask, and then that we will review it and provide written notice. Again,
Kate, I have a question.
Yes.
Sorry. Right there, can you possibly just elaborate a little bit on this number 1, a copy of each regulation or rule applicable for conducting the tournament? Kind of what is that, or maybe an example?
Yeah, and Bart, at any point, please chime in. This is more of your realm and regulation update, but I will gladly give what I'm assuming this all means. that would be any regulation that would be applicable for that particular tournament. So if we have a regulation about that particular sport and how a tournament is run in that sport, I'm assuming that's what we're looking for. Bart, do you want to add to that?
Thank you, Kate. If nothing else, I'll give you a break here for a second or two. We
Thanks.
do have some tournaments that will operate by different rules than the NFHS. For instance, may have a basketball tournament where times are pretty tight in between games. So what they may do is say, instead of 5 fouls per quarter before you go shoot free throws, we're going back to 7th foul of the half because we're going to play a 16-minute half instead of 8-minute quarters. Things like that, so that we know ahead of time what's going on and nothing becomes a surprise to any team involved or anybody in any association involved.
So it's different, or is it similar to the format?
It would be, it's different than the format. The format is, if you're playing pool play, if you're doing bracket play, if you're doing double elimination, that's the format of a tournament, so that we know. Let me give you an example. The Tarkanian Classic, for instance, that Bishop Gorman hosts. They have a format where they have teams broken into all sorts of different divisions. Some of those may be prep school teams. Some of them may be NFHS sanctioned teams. Many of them are our teams. We want the format of the tournament so that we make sure that our schools are not competing against teams they shouldn't compete against. What we're looking for when we talk about the regulation or rule applicable for conducting the tournament is there anything that's a little bit of a tweak from what you may see in the rule book?
Thanks, Bart. Anything else, Ellen, on that, or anybody else? Okay. Section 5, this is our regulation regarding schedules and the submission of those schedules to our office. And so we added some language, again, has already been approved, but just to remind everybody that we want to be a little bit more specific. It has to be all of your league games. Sometimes we just get just the league games and not the non-league or out of state or tournament. We need everything, anything you're participating in as part of that submission, using a process that we have, has our dates in there for when those are due. That is unchanged. And then the new addition, which we talked kind of extensively about when we first brought this regulation up, was that the schools need to notify the association of any changes to that schedule within a reasonable, practical time. You know, we're not going to fine if you knew the change and you didn't tell us for an hour or something like that. Like, we're not going to be like that, but we need to know about those changes because it's important for us and just our, you know, specifically for Bart and his tracking of schedules and standings and all of that. And then 3 just references that if you are in violation of any part of this section, so not getting your schedule in on time, it not being complete, not notifying us of changes, that you could be fined. For those areas like the Southern Nevada area that has a wonderful person that does all of the scheduling for them and handles all of those schedule changes, we're notified through that office. So I think that was a question that came up before. I just want to kind of reiterate that, you know, when Xavier sends Bart the email that this person canceled a contest, he's doing that for them. That change is they don't need to also tell us about that change, just as a side note. Any questions on that? Okay, section 6308. This is our regulation about the ability to participate in contests in other states with schools that are suspended or prohibited from participating in their athletic association. Basically, so you can't play any club programs or any school that is currently not in good standing in their state. And we wanted to just add the language about being in state or out of state, since sometimes they think because it's out of state, it doesn't really matter. And then added language about possibly being fined if you are participating against a club program or program that's not, you know, in good standing. Section 7.
Okay, this is Dennis Holmes. Can I?
Yes.
So I want to back up, if you would, to that number 3 right there. So it says the association will impose a penalty against the school that violates the provisions of this section in accordance with NAC. Should if it says we're going to impose a penalty, shouldn't we define what the penalty is, or is there no longer a dollar amount attached? Or
yes, So every single regulation that had a dollar amount, we had previously gone through and updated to just reference
Okay.
960 because that has a specific continuum that we actually increased some of those amounts. So
Okay.
150 was the first, now it's 250. So 960 has that full continuum for everybody.
Thank you.
Yep. Okay, back to 310. This is our regulation where we basically can allow a school, like this is where we have those schools that get permission to play. You unless you have that approval by the executive director, you cannot play with any school that's not a member of their affiliate or affiliate of their association or their athletic association of their state, has been suspended or expelled. And again, referencing, it doesn't matter if it's in state or out of state. And if you violate, there could be a fine. So similar language between those two, but a little bit different. Questions? So again, the only change to all of this entire file was just changing the link for the NFHS.
Hey, sorry, calling not region 4. Just a question on this, the penalties for kind of to Dennis's point. What so 960, right, outlines the various penalties that exist, right?
Yeah.
Insofar as like the beginning of it says imposition, whatever, adding additional penalties by the association or executive director, approval of suspension by the board. What does that? Can you just elaborate on that, just so we're clear on like the
Yeah.
penalty
Suspension part?
process here, the penalty process here, and then like it can lead to a suspension, but can you just clarify for me how and
Yeah.
what the board's role in that is?
Yeah, so the board would only be involved if it got to a suspension, which would literally be that they no longer are in good standing as a member school, can't participate in the NIAA, things like that, which it rarely, I don't know if ever has come to something like that, not in my knowledge. But generally speaking, if you look at just the simple fine, which is the 250, and then second offense is the 500, that is where all of these regulations where it's like missing a deadline, not submitting a roster, not, submitting your schedule, that's where those fall in. So 250 would be your first offense. If it happened in the fall and then you forget in the winter too, it would probably be 500 for that school year again, and then it kind of resets going into the next year as far as that first and second offense, and then it's any further offense it says 500. So it'd just be 250, 500, and then it would continue at 500 in that same school year. We've kind of just looked at clean slate for the next school year. Hey, let's start back from the beginning. As far as going into like probation and things like that, for something like this, unless it really was something that was out of hand where we just were, left and right getting complaints about, the schedule being incorrect and they're playing against all these teams that are clubs and just continuing issues, that would be when we would entertain a possible probation where they could be postseason ineligible or something like that. But generally speaking, this stuff that we're talking about is just that 250, 500, 1 and 2 and on.
Copy. Thank you. And the board, what is the board's role in all of this? Does the board have authority to because if the school appeals, I guess, for example, is that where the board, because it says on here like approval of by the board essentially. And so that's what I just wanted to clarify in 960.
I have to pull it up to actually look exactly at, let me just look what you're, just 1 second. Which section, subsection?
It's actually in the title of 960.
Okay, so that would be the suspension part. So let me just look really quick.
So the board does not approve necessarily the fines, right? Or appeal fines,
No.
right? The board's involvement is when it escalates to the next level.
Yeah. Yeah, the appeals have always been just, if they appeal, it's to Tim because I do the initial. So it then goes to him if they want to appeal a suspension. Or I'm sorry, a fine. But when it goes to the suspensions, like I said, that's like a full suspension of like their actual membership. And so that would be something the board would be involved in.
Got it.
But
So
not.
I guess, yeah, subsection 4, Kate, I guess clarifies it
now.
now that I'm reading it, right? A suspension imposed pursuant to this section is not final until the board approves the and duration,
Yes.
right? So
Yep.
yeah, got it.
Yep.
Okay, that helps clarify that. Thank you.
Yep. Anything else on that file in general? Okay, so from here, if approved, it then just goes back to the LCB to be sure that change in the link is okay. May have to come back one more time with that new link in there before we can send it to a hearing. I think we're good for a motion, Pam, when you're ready.
Okay. With that said, I'm looking for a motion to approve agenda item number 11, approval of the regulation return from the LCB. Need a
Madam
motion?
Chair, Alex Woodley, so moved.
Thank you, Alex. We have a first.
Rayanne Sorensen, second.
Thank you, Rayanne. We have a first, we have a second. Any questions, comments? Hearing none, all in favor, say aye.
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 Right.
Any opposed? Thank you, Kate, for the work. All right. Let's now go to item number 12 on page 65. Contract with Neil Rombardo as the new legal counsel for the NIAA. I'm gonna turn it over to Mr. Jackson.
Thank you, President Sloan. You can see before you the agreement for legal services that was worked up between Mr. Anderson and Mr. Lombardo. Paul, if you want to step in here, I'd appreciate it, as this is all the legalese.
Sure.
Thank you.
I'm happy to do that. Yeah, so at the last board meeting, after you approved Mr. Lombardo as your new legal counsel, I was asked to go ahead and draft the agreement that would be executed between him and the association. So these 4 pages or so are what that agreement is. And as Tim indicated, Mr. Lombardo and myself, and with Tim included, went back and forth on this a few times. Nothing we really argued about, but just to make sure that we were clear with respect to what was being set forth. And just to walk through it, we've got under the general provisions, the term of the agreement. It would begin on March 1, so next Monday or next week, and continues until either party terminates it in accordance with what we've got in paragraph G of this first section with general provisions. There's also, and Mr. Lombardo had asked for this, he's quoted you a fee, which we'll talk about here in a bit, but on or before, he wanted a 6-month review of the agreement just to see how things are going, since this is a new engagement for him. And so on or before September 15th, the board you would have a meeting just to review the agreement and either determine whether there's any changes that need to be made or not. Section B's relationship of the parties. We wanted to make it clear that it's Mr. Lombardo's LLC that's contracting with the NIAA. And that's what we set forth there, just to make it clear that he's an independent contractor. It's his LLC that's the entity that you're contracting with. And then C are the professional services, as we did in the past, and typically the general professional services, which I've broadly defined and given a few examples of in number 1. That's what's covered by the monthly retainer amount. And then if the entity, the association, the board, or anybody are sued in court, either federal court or state court, then the litigation provisions kick in, and that's subsection 2 there. So we've defined that. You go to D, and that kind of defines how payment will be made. The monthly retainer for general services, Mr. Lombardo indicated that he would start at $7,500 per month. And so we outlined how that process will work. He'll submit an invoice on a monthly basis with his retainer amount of $7,500, plus any costs that he personally incurs, travel costs, that sort of thing. You can see the last part of that paragraph. I've defined that. Those are added on and just submitted monthly to the NIAA for payment. as far as litigation fees, we wanted to define an hourly rate. We put that in at $3.50 an hour, billed in 1/10 of an hour increments. So as I said earlier, if the association or the board or anybody are sued in either state or federal court, and Mr. Rombardo is the attorney who's retained to defend, then he will be billing it at that separately from the retainer at $3.50 an hour, as stated, billed in 1/10 of an hour increments. And then item 3, there's just how he will be paid, and that would be within 30 days of receipt of invoices from the NIAA on either 1 or 2 or both. The next item, E, the errors and omissions, that was one of the provisions that the board specified back in January, and was part of the application process, the expectations in terms of liability insurance that the attorney would provide. The application required 1 million per claim and 3 million aggregate coverage. Mr. Rombardo has worked hard to secure insurance. As an individual, it's not easy and it's expensive. He has quotes, from what I understand, and Neil, you could certainly jump in here, but he has quotes that would allow him to provide the association with his declaration page showing he's got 1 million per claim and 2 million in the aggregate. So not able to get the 3 just because of cost factors. It's a significant jump between the 2 million and the 3 million aggregate. And frankly, I think that's something you could look at and approve, because as a public entity, if the association sued, if any board members sued or whatever, it all falls under NRS Chapter 41, dealing with public entities, and the liability limit that is set forth in Chapter 41 of the Nevada Revised Statutes for public entities and public officials who are sued. There's what we call a limited waiver of immunity to, so that you can't recover more than $200,000. So the 2 million coverage would be adequate coverage, I would believe, with anything that may come up. If the association were to make a claim back against their attorney for what they felt might be errors or omissions in his representation. I don't know if anyone has any questions on that. We can address those. And Neil, I don't know if you want to jump in here. You're there, I think, right? I don't see on my screen, but
Yeah, I'm here, Paul, and
okay,
thanks,
there you go.
Paul. If I may, quickly. Yeah, I've reached out to multiple brokers on this. My personal broker, I talked to him, and his response back, which I thought was odd, but he basically said there's so little risk here, and you're asking for such high numbers that they're just going to charge you a very high premium. And I had shared with him the 1 million, 2 million that I received through the Nevada State Bar Association. And he said, I would just go with that. It's just not worth it for you to do the 1 million, 3 million. However, I wanted to honor what you asked for, and I went out to another broker who does commercial work similar to this, and she did get me a quote, but it's nearly 5 times the amount. It's over 4 times the amount of the 1 million, 2 million. So I'm asking, and I'm hoping that the board would be comfortable with 1 million, 2 million. As Paul pointed out, your cap is 200,000 for claims against the NIAA, even individual members. So that's really what it boiled down to. It's, like I said, nearly 5 times. I was really shocked by that. The insurance company that I will contract with, presuming this is fine with you, I will do it today. I have the application in. I just need to push send. Then they are the preferred company by the Nevada State Bar Association. So I hope that gives some comfort level to the NIAA. Thank you.
Does anybody have any questions on that? Hearing none, I'll move on. Item F is the professional licensing. That's just the requirements that are placed on Mr. Rombardo to maintain his license in good standing. And that's his responsibility as an independent contractor to make sure of doing that on an annual basis and meeting continuing education requirements and any other requirements that the state bar places on each of us as practicing attorneys. So he's agreed to do that. Then item G, as I mentioned earlier, is the paragraph for the agreement for termination. The contract will continue unless either party wants to give the other, written notice of the intent to terminate. And that I put in a 90-day requirement. I think that's a fair amount of time. Most contracts you'll see a 30-day, period of time. I think with, with your professional services, legal services and that sort of thing, it needs to be a little bit longer just to make sure that anything that's pending, is covered by the time the attorney terminates one way or the other. Section 2 are just miscellaneous provisions that you'd see in most contracts. I did pick up one little thing that all of us missed. Item G, the invalidity provision. The last part of that should say any term or provision shall be deemed not to be a part of this agreement. So I just have to add a not to the last 6 words of that provision there. And that's really it. If anyone has questions, like I say, I'm happy to answer those. And if you have any questions of Mr. Rombardo, I'm sure he'd be happy to respond.
All right, thank you. So Paul, repeat again, is it number G? You need to add the word not.
No, it's under miscellaneous provisions. So the general section 2, miscellaneous provisions, item G, invalidity of agreement provisions. I'll just read it. Should any provision of this agreement be declared or determined by any court of competent jurisdiction to be invalid or unenforceable, the legality, validity, and enforceability of the remaining parts, terms, and provisions shall not be affected thereby, and the illegal, unenforceable, or invalid part, term, or provision shall be deemed not, I need to add the word not right there to be a part of the agreement.
Got
It
it.
just says if there's one paragraph here that's not legal or whatever, or is determined not to be or whatever, it doesn't invalidate the rest of the contract.
Okay, thank you.
Mhm.
All right, so the motion will have to read with the addition of. All right, any questions, comments for anyone? Okay, hearing none, I'm actually looking for a motion.
I make the motion to approve the contract with the change to section G to include the word not.
Thank
Madam
you.
Chair, Alex Woodley, second.
Thank you, Alex. Have a first, we have a second. Any questions, additional questions, comments? Hearing none. All in favor, say aye.
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 Any opposed? Thank you. The ayes have it. And Mr. Rombardo, welcome aboard.
Thank you. I look forward to working together. Appreciate it.
As I intimated earlier, I will bring the copy over for you tomorrow to sign at your office. And
Yes,
then Neil, I will send you the signed version for you to sign as well. That way
Great.
we'll end up, and then I'll forward the other one back to Pam so that both parties have totally signed copies.
Great.
all
Thank
right,
you.
thank you. Again, welcome aboard. All right, let's proceed now to item number 13 on page 70, public comment. This time provides an opportunity for citizens to address the board about any matters not on the agenda. Items raised during this portion of the agenda cannot be deliberated or acted upon until the notice procedure of the open meeting law has been complied with. Should a member of the public wish to speak on a matter not listed on the agenda, it is asked that the said person please complete a yellow public comment card and submit it to the president before the opening of the item, limited to 3 minutes per person and/or 5 minutes for the spokesperson of a particular group may be imposed. It is requested that comments be directed to the board as a whole. Comments that are determined to be irrelevant, repetitious, offensive, inflammatory, willfully disruptive, disrupted, or deemed to be personal attacks will not be permitted. I do not have anyone. Tia, Tim,
Nothing.
Tia?
No.
Okay. All right.